abusuafo yɛ ma mo nyinaa mo akɔ ababa for 1GHB. Abusua Chief Justice ɛho nsɛm na ɛkɔ so sɛ ɛni kwan sɛ case bi wɔ ha wotumi gye anaasɛ ɛnyɛ sɛ ɛni kwan sɛ ɔni ho kwan sɛ wotumi gye cases bi tum sɛ ɔno no release some cases. Na abusua saa nsɛm wei ɛkɔ so ɛkɔ so saa wɔ ɔman Ghana ma big political parties mmienu a kyerɛ sɛ the giants NPP ne NDC ɛka ho nsɛm yi saa na abusua ɛyɛ former anaasɛ retired Chief Justice a yɛfrɛ no William Atuguba abusua William Atuguba aba ɛde no abɛto nsɛm na abusua ɔbaayɛ no wamba no peacefully koraa cause ɔba nyinaa no ɔse nneɛma bi sɛ akɔ so ɔman Ghana akyɛ nti abusua wɔteki the Chief Justice current Chief Justice no wateki no on part so waka biribi akyerɛ no waka no boso nsɛm nyinaa akyerɛ maame no abusua no yɛnim sɛ maame no bɛsɛ saa na so ɔbɛbɔ nsɛm ato abusua mɔ meyɛ nsɛm mmerɛ koraa deɛ nkɔtie sɛdeɛ Chief Justice former Chief Justice ɛyɛ Justice William Atuguba is me Kasachere, current Chief Justice.
Morning.
And it's always good to have you. And I know that you have seen this recent ruling in this 109-page document as released by the Justices of the Supreme Court within the week on Thursday. One of the issues that has become a matter of concern is the matter of jurisdiction. The 5 justices who ruled in favor of the plaintiff, Alexander Afenyomakin, is saying that even if the case was filed at the High Court and the interpretation of Article 97(1)G and H became a bone of contention, the High Court by Article 130 was required to stay proceedings and refer the issue to the Supreme Court. But in the contention of Justice Amadou Tanko, this procedure is not that which was employed in this case. And as a result of sidestepping this procedure of this High Court's jurisdiction being invoked on this case, but rather going directly to the Supreme Court, it negates the Supreme Court's jurisdiction on this particular case. I want to find out your thoughts on this matter of jurisdiction, whether it has been settled, really, by the recent ruling.
Thank you. This question of jurisdiction ought to have been regarded as settled long ago if the court was minded to follow precedent. Well, the court is bound by its previous decisions. It can depart from them for good reason. But there came a time this provision about stare decisis has virtually been negated. You'll find in the latter days, can take it from, let's say, 2012, thereabouts going. You find there's complete and frequent violation of that rule of stare decisis. The question about the jurisdiction in this matter, I mean, could not have been a serious problem if these stare decisis were observed. First of all, even let's ask a very common sense question. When parliamentary results are declared and people are contending that they rather should have been elected, the results were not fair, where do they go? Is that to the High Court? And who has ever said that that's the wrong forum? Common sense. And this common sense is supported by the provisions of the Constitution. Otherwise, how could it have been happening? Unchallenged. But suddenly, No, beginning from, I think, the beer bell case. Second day, Amado and beer bell versus second. No, he rather even went a second day. Here was a case that concerned the validity of the election of the MP for Boku Central, I think. The challenge to his election went to the High Court. It was thrown out while it was out of time. They went to the Court of Appeal, and they failed there. And then a new action was brought to the Supreme Court. This same situation arose, I think, in 1997 or so, in the case of Yeboah versus J.H. Mensah. I was on that panel. Let's briefly state the facts. J.H. Mensah, I think it was from Sunyani or so. He didn't contest that particular election from where he hailed from. That's Sunyani. He went to another place, and he did not reside there for a continuous period or an aggregate of 5 years, no? As required by the Constitution. And actually, if the plaintiffs had taken that matter up in the High Court within the 21 days, he would have been thrown out of Parliament. Because he clearly was not satisfied. But they waited until that period had expired. And now, and that's where I want always to be forthright. This man turned out to be a problem to the government of the day in Parliament as a minority leader. And I think some felt that should be a way to get him out. They then found that the High Court gate was closed, so they sought to circumvent that by coming to the Supreme Court. I was on the panel. And the issue, now interestingly enough, it was this our same president who was counsel for J.H. Mensah. And he contended that the Supreme Court had no jurisdiction. It was a parliamentary matter. Now, we're confronted with the previous decision of Weduma versus Awana Williams. That was decided in 1969 by judges one dares not to disagree with. But that is beside the point. When this matter came before me, I must confess, I was suspicious. Why is it that after all this time they are coming with this matter? Is it because the man is a pain in somebody's flesh? So I said to myself, if I look at this matter and I find that, you know, there's no jurisdiction, I'll throw the case out. That was my approach. So I read that Weduma versus Awana Williams.
Yes.
And Azu Crab, who read the judgment, who wrote it, said that on the issue of parliamentary election, the Supreme Court and the High Court had concurrent jurisdiction. So I had to consider this one over and over and over as a pure legal question, not question of politics as we are doing today. And I found that notwithstanding their distinguished judicial status. I couldn't agree with them that when the Constitution says in Article 130 that subject to the High Court jurisdiction of fundamental human rights, the Supreme Court shall have exclusive jurisdiction with regard to interpretation and enforcement. It can at the same time, how can something be exclusive and be concurrent at the same time? So when I got to that idea, I said, no, I will not accept their reason. And that found me to rule in favor of J.H. Mensah. We're 5 on the panel, only 1 dissented. We took time, wrote lengthy judgment and analyzed. When BABL case came, the lead judgment didn't, as far as I can recall, didn't deal with that, didn't try to see whether we're right in departing from Williams and Wedma, nothing. Just said that, each time that the person continued to sit in the Supreme Court, in the Parliament was a new course of action. Now, I don't see this in it, because there's one provision governing the status of the elected person. And in my opinion, that makes it an action in rem. It relates to the status of the elected person, not an action in person. So that accrual of course of action keeps on. And even if it is, the express limitation period is there. So, we departed from our Williams and clearly established that in matters of parliamentary tenure, election, validity of elections, and so forth, the High Court is the proper forum.
The High Court is the proper forum?
Yes. For the determination of the validity of a parliamentary election. And of course, by extension, that's just one item of that jurisdiction. If there are others, also like vacation, it simply follows common sense, common logic, that the same thing will apply.
So in that sense, the Supreme Court shouldn't have even entertained this particular case at all?
At all. Now let me emphasize. A jurisdiction to interpret and to enforce under Article 130 is described as an original jurisdiction. I'm saying that in a situation like this, they don't have original jurisdiction. What they have is a jurisdiction of reference. The subject matter belongs to the High Court. And the same Article 132 makes it clear that in a situation like that, they have only reference jurisdiction. So I don't see, I don't know. That's why I'm emphasizing. And I think that at the heart of all this pretentious discussion going on, there's no true legality involved. It's just politics, that honorable type. All we are doing is the paramountcy of political partisanship. Partisanship. That is what is controlling this country. If that is not addressed, we are just wasting our time. True law no longer will apply, where the basis of anything in this country is political, politically driven. That is the menace. I agree with Martin Kwebus's observations along these lines.
He's talking out of passion. But right now, he's not under anyone's control anymore. And I say, Ghana constitution biara nhyɛ no sɛ no wanyɛ sense no waba abɔnten ɔbɛ kyerɛ mu sɛ ɛsɛ yɛtumi sɛ sane ɔbɛ nso wotie papa no kasa no a wotumi sɛ na papa no antena hɔ kwa he's talking out of experience and he's not just saying anything said the nkɔfo bi bɔ mbɛtena hɔ na wakeka nsɛm toto paapaa so na ɛmfa kwan mu wotumi sɛ ɛnyɛ saa na wɔka whatever he's saying makes sense na sɛ no wosimi kasa about parliament ne chief justice ne supreme court ne deɛ ɔmayɛ ɛn deɛ abusua yɛntie papa no asɛm ne yɛmfa yie nkɔto yie dɛ monkɔ so hwɛ video no kɔ so ɔka nsɛm paa.
That is a fundamental matter. Unless it's arrested, this menace, this vice will continue to fester, and constitutionalism will be subverted. Paid lip service to people suffer. In other words, we are not entitled to benefit from the constitutional order put in place for this country. That is the true situation. That's the true evil to be addressed.
When you make reference to the fact that clearly the Supreme Court shouldn't have entertained this case at all, in the recent ruling of the 5 who ruled in favor of the plaintiff, they argue that although the High Court had jurisdiction with regard to whether a seat is vacant or not in Parliament, what was before them was purely a question of law regarding the true interpretation of 97(1) and H, and not factual disputes regarding seat vacation in Parliament.
Sorry to say that's superficial reasoning.
That's superficial reasoning.
Yes. It is not, but that issue has been addressed by Article 132. Now, where it arises in a matter belonging to another court, the Supreme Court only comes in when an interpretation or enforcement issue arises and is referred to the Supreme Court. That is the only time they can come in. So you don't, take 132 about is it not dealing specifically with that question of law that they are talking of and how it should be brought to the Supreme Court?
Indeed, 132 says where an issue that relates to a matter or question referred to in clause 1 of this article arises in any proceedings in the court other than the Supreme Court, the court shall stay the proceedings and refer the question of law involved to the Supreme Court for determination, and the court in which the question arose shall dispose of the case in accordance with the decision of the Supreme Court.
Yes, that is the constitutional order. And let me say this, those days that law was, there was fidelity to the law. And even today it's reflected in their judgment, the majority judgment. Jurisdiction is a fundamental matter. So the conditions upon which your jurisdiction arises, if they are not there, you don't have the jurisdiction. And that is it. That this matter is directed to the High Court. However patent the constitutional issue that may arise there, you don't have original jurisdiction, you have jurisdiction of reference. That is it. Is that what they exercised? That's not what they exercised. They purported to exercise original jurisdiction, whereas in this kind of situation, it is only reference jurisdiction. It's quite clear from the same provisions of 130.
So as the Supreme Court has always held consistently, a point of jurisdiction, when taken and successfully upheld, should foreclose any consideration of the merits of any case.
Completely. You don't have jurisdiction, how do you touch the merits? And even in the majority, there is clearly and plenarily stated therein, and I agree with that. Even they are saying as is solidly laid down that as for jurisdiction is so fundamental that even if the parties don't raise it, the court itself suo motu ex debito justicia.
So sounds like there will be no foundation upon which the merits can stand.
At all. How can you put something of Macquarie and USC? Mosi and Bajina? Macquarie and USC, I think it's something, but as for Mosi and Bajina, I think it's 1963, volume 1, Ghana Law Report, page 634 or so. Supreme Court. Atuguba ASC wrote that unanimous judgment. So, I mean, you don't say that the same issue would have come. The thing is, when do you have jurisdiction over the issue in a matter that is consigned to a lower court? That is it. No, you don't substitute desiderata for, actuality of jurisdiction. Supreme Court.
Well,
Anyway,
Justice, I want to make the point and say that to the extent that this matter of jurisdiction is a problem, Justice Amadou says that he finds the decision of the majority as an aberration to the established and accepted judicial position of the Supreme Court, which, with profound respect, he says he hopes in no distant future the resultant usurpation of the constitutional prerogative of the High Court incidental to the majority decision will be reversed. You agree with that?
Well, yes, but the thing is, as I've told you, in the course of time, the Supreme Court was not faithful to the constitutional prescription of stare decisis. So you find Biebel and Sakande going off tangent, entertaining a matter that should have been commenced in the High Court, and then some followed. It's very interesting. If you read that Biebel case, and look, the Doce and another justice, that's interesting, eh? They disagreed with the majority decision on the grounds that I'm canvassing. The same grounds. That's very interesting. I think when in human life, it's important to apply realism than that things. That's very significant that happened. The majority decision didn't even discuss, if I remember well. I'm yet to go back to my books. It's 6 years since I've retired, but I think recollecting.
Indeed.
They did not examine Awana Williams and Vedima. They did not examine Yeboah and Mensah and so forth, and try to demonstrate why those decisions should not bind them. That is, from a certain time, the Supreme Court, after that, you started sliding down judiciary. I'm telling you. You find that this stare decisis was not observed. You find a panel taking a decision one way, then another case comes. Either the same panel or a good number of those who decided would take a contrary stand and then back and, this wasn't happening before. That's why I'm saying something fundamentally has gone wrong. That is what has to be redressed. If we are to get back on track and run this country properly and not politically and myopic. Now,
Sir, and you think that politics is a cause of this, that the judiciary continuously being drawn into politics? Because that was a concern by many, that this case may have just overly exposed the judiciary to the politics of it, sir.
Yes, you said?
Sorry, I lost you briefly then. You are talking about the problem that we have, the problem that we are faced with now. And
Yes.
the concern that was raised when this matter started was that this was going to open up the judiciary for the politics of this particular issue. And do you see that as a problem here?
It's a problem. That's a realistic problem. Now I'll demonstrate it. Look even at the empanelment. People has referred to all those. I mean, for what reason will you bring the younger justices to handle such a weighty matter to the exclusion of the seniors? What reason? I mean, this reason, sir. Then they brought in these two others, but I mean, what were they going to do? In fact, even legally, I don't see whatever was left for them to decide on the substance, because in rejecting the application to set aside their injunction or their directive, they had ruled that they had jurisdiction. They had already decided that they had jurisdiction. The speaker had no jurisdiction over the matter. It was so. What was left actually for determination? You know? And so, and these same 5 who ruled that there was jurisdiction, they were still there, and only 2 came, and the 5 went the way they went, predictably.
So it was predictable?
Oh, sure. Are you not in this? Don't you follow the horizon of judicial functioning in the Supreme Court? Are you surprised? Tell me honestly, were you surprised?
The way that the 5 justices went on the particular case was predictable.
And let me tell you, why wasn't it being let us even go by pretentious legal theory? They're not the same person who had ruled on the the application to set aside their processes, that they had jurisdiction. And so, I mean, if the same people are to pronounce again on the same matter,
Okay.
don't you see
Yes, indeed. It was the 5 who sat on the speaker's application. Yeah. Yes. So the dissenting 2 were only added on the substantive case.
Yes. And what could 2 do against 5? Look, as I've said some time ago, this question of political poison in the judicial system didn't start today, but it has gotten to, I mean, its peak under this current administration. It has gotten to its peak. But some position must prevail. That's why this
espoused continues. Sir?
Why do you want to establish an independent judiciary and the president is the appointed? And even if you look...
Sir, Justice William Atuguba, retired Justice of the Supreme Court. Thank you. Thank you.
abusua yɛda mo nyinaa mo asesa mo hwɛ video yi abusua mo a monim deɛ ɛkɔɔ so last one ɛyɛ Sam George ne some other panelists na kyerɛ sɛ ɔmo nyinaa ma standing ovation abra papa Justice William Atuguba ɛde ne nsɛm siiɛ no ɔmo nyinaa stand up a kyerɛ sɛ ɔmo bɔ ɔmo nsɛm papa abusua kɔmɔ bɔ mmɔden sɛ ɔbɛ like ɔbɛ comment no wahyɛ. Thank you for watching.